mentioned that.
I'm sorry, please.
You mentioned that one of the situations in which your interpretation would apply is where this court has reinterpreted the meaning of a substantive criminal provision. Where else would it apply?
Well, Your Honor, I think it could potentially cover some of the situations the amicus has identified, although some of them, I think, frankly, wouldn't even fall into 2255 in the first place. Federal habeas corpus is really divided into three parts. The first one is like challenges to conditions of confinement or good time credits, things that challenge the execution of the sentence rather than its imposition. Those don't even come into 2255 in the first place, and there's really no need for anything to exclude them.
When you speak about the traditional scope of federal habeas corpus, at what point in time are we supposed to look?
So, Your Honor, you look at federal habeas corpus now, and the body of federal habeas corpus now can be informed by Section 2255 itself and its limits, and the limits that Congress has imposed on state prisoners through 2244. And if I could just take a second to explain why that is. I think there are certain circumstances in which we can draw negative implications from 2255, particularly when they're reinforced by 2244, which the explicit limitations on constitutional and factual claims in 2255H definitely are, because they are mirrored in 2244B. And in fact, and 2244 is expressly cross-referenced in 2255H. And then if you look at 2244, it has a provision 2244A. 2244A literally only applies to a second or further habeas petition that a federal prisoner might file, so it doesn't literally apply to a 2255 motion followed by a habeas petition. But one thing that it does is it points back at 2255 for the relevant limitations. Those relevant limitations include, this gets back to Justice Jackson's point, 2255H, which limits successive or abusive constitutional and factual claims, but doesn't say anything about statutory claims.